Okay, it is 10 o'clock. And I say we get going. I'm not sure if this will take the whole hour, but we'll see how it goes. So any questions, and I hit record, so I'll post this as well. Any questions on anything you guys have? I see a lot of repeat customers here. Anything we've talked about in the past 3 or 4 days, however long we've been doing this, before we move on? Okay. So 22D optional clauses. Okay, paragraph 1. So paragraph 1, you know, I've talked about skipping lines or not checking boxes. Paragraph 1 is a head scratcher when I don't see that box checked in a contract, because remember I've talked about crosshairs, and the crosshairs are always trying to land on us, right? We're the ones that get thrown under the bus. We're the ones that get blamed for everything. And so we always have to be aware of that and trying to get those crosshairs away from us. Paragraph 1, when I look at paragraph 1 and it says square footage, lot size, encroachments, and it goes on to say the listing broker and selling broker shall make no representations concerning. I don't care what it says after that, you guys. Check the box, right? This is a great paragraph to help us get those crosshairs away from us so they don't land on our forehead. So this just says, hey, don't rely on us, buyer and seller. You know, that's outside our scope. It's not our fault if there's an issue down the road on any of this information regarding the size of the property, whether there are any encroachments. And buyer is advised to verify this stuff. So check the box, please, so that helps to establish that we're not responsible for any inconsistencies with these types of details. Okay, so check that box. Now, paragraph 2 is the one paragraph where in most cases you will not have a box checked. We always talk about check the box, right? Well, paragraph 2 is a little different, because paragraph 2 is with regards to title insurance. And when we were talking about Form 21, whatever day that was, and paragraph E as in echo in Form 21, that paragraph provides, in most cases, the appropriate title insurance. Now, paragraph 2 in optional clauses gives the buyer the option of selecting less than what Form 21 gives us, or more than what Form 21 gives us. And paragraph 2, years ago, we had to add that description next to 2. It used to have the boxes, but the description says the title insurance clause in the agreement is Form 21. The title insurance clause in the agreement provides seller is to provide the then current Alta form of homeowner's policy of title insurance. And it goes on to say the parties had the option to provide less by selecting standard, or more by selecting extended. So if you don't check any box, paragraph E in Form 21 dictates the type of level of title insurance. But a lot of times we'll see buyer brokers check the box standard. And I get it, because you're thinking, well, we don't want anything exceptional, just the standard title insurance is fine. But they're not reading the language above that, which says that is less than what Form 21 already gives you. And at least here in Spokane, the title companies here, if they see a contract that's checked with standard, they will still give you the title insurance described in paragraph E, because they say they know you made a mistake and you're not aware of what you're doing. So I really wouldn't expect to see the standard box ever checked. Or you could check extended, but now with extended, what this says is seller authorizes buyer's lender or closing agent at seller's expense to apply for an ALTA or comparable extended coverage. I'm going to mute people.
Ask your customer.
Where's the mute? Okay. Extended. Seller authorizes buyer's lender or closing agent at seller's expense to apply for an ALTA or comparable extended coverage policy of title insurance rather than what paragraph E already gives you. And then check out the next sentence. Buyer shall pay for the increased costs associated with the extended policy. So we see some buyer brokers check extended when they don't need extended, they don't need a survey, they just think it's better and I want to get it for my buyer. Well, you've just subjected your buyer to additional costs. So I think it all comes back to just slow down and read, because again, if you read paragraph 2 before you get to the boxes, that paragraph explains what the boxes below, standard or extended, what that means. So again, with paragraph 2, in most cases, we're not going to see a box checked. It's just going to be per paragraph E in Form 21. Does that make sense? Okay, let me, all right, I'm not seeing any questions, so we're going to keep going. Now, paragraph 3 and 4, with the revisions last July, were separated. It used to be one paragraph, now it's separated into 2 paragraphs. So paragraph 3, pretty straightforward, on paper at least. Seller shall clean the interiors of any structures and remove all trash, debris, and rubbish from the property prior to buyer taking possession. So seller, you're going to clean the place and get rid of all the trash, debris, and rubbish. Now, I had a broker one time in class ask me, define clean. I don't know. We all have different definitions of clean. My wife has her definition. I have my definition. So I can't define clean for you, but you got to advise your seller, of course, that you got to get this stuff out of here. I know that doesn't always happen. A lot of us have probably written checks to help this get accomplished after closing. But nonetheless, if you want paragraph 3, check the box, okay? And then the second half that was split out is paragraph 4. If you want it, check the box. So paragraph 4, personal property, unless there's any other agreements, the seller shall remove all personal property from the property no later than the possession date. And any personal property remaining shall become the property of the buyer and can be retained or disposed of as buyer determines. Now, when this paragraph was born, July 2019, I thought of some issues around it. And I'm not sure how to completely ensure that the buyer's not going to have to deal with any of this personal property that's left behind. But when I saw this paragraph, I thought of immediately, and some of you have heard this story. When I was a bachelor, right? I was a commercial real estate broker in California, and my was with a property that I would take over and sell whatever. It was a typical bachelor pad. My kitchen table would be anything that would, hold my food. I didn't care what it looked like. It could be a desk from some insurance company on a building that I sold 6 months earlier, right? Who cares? I'm a bachelor. I'm not going to spend money on a big table. My patio furniture came from an insane asylum that I sold. How many people have sold an insane asylum? I have. So that was the stuff that furnished my condo. Then my wife comes into my life and we buy a house. Well, that stuff's not going with me. So let's say I put my condo on the market and it's controlled by this paragraph. Personal property, seller shall remove all this stuff. And if I don't remove it, it says buyer may retain or dispose of as buyer determines. Well, when I left that condo, my container was full. I didn't have room for that stuff. And that stuff's not going with me, right? Because my wife, there's no way it's coming with me. So if I had this contract, it's not trash, debris, rubbish. It's a kitchen table. It's patio furniture. What would stop me from just leaving it and let the buyer deal with it? Because I don't want to take up space in my moving container. I don't want to pay for labor. I don't want to deal with it. I don't want to have to take it to the dump, but it's not trash, debris, or rubbish. So this paragraph got me scratching my head and thinking about that example. What would you do? What can you do? And so I asked Annie that question back in July when we were going over the revisions. And she said, well, Ken, typical answer, you would have to advise your client to seek legal counsel. I get that. But my problem with that is this paragraph already determines what's going to happen, because it says any personal property remaining shall become the property of the buyer and may be retained or disposed of as buyer determines. And based on my experience being in court, and look, 25 or 26 years in real estate, 12 of them being a commercial broker, and there was a period of time, about a year and a half, where I was taking over buildings, apartment buildings and commercial buildings that were in foreclosure, and I was selling them. I was in court a lot. So I have a handful of experience being in court. And my experience has told me that when the language dictates what's going to happen, that's what happens. So I get Annie saying, well, you got to go to a lawyer. But in my experience, it would come out to, well, buyer, it's up to you what you want to do with it. The paragraph already determines that. Now, I don't know what would happen in Washington, and I'm obviously not a lawyer. I'm just saying those are things to think about. If you see a lot of personal property and you're scratching your head like, oh my gosh, are they going to be able to get all this out? Yeah, don't worry about it. Don't worry about it. And I know what some of you are thinking, because you've said it in class, well, we'll just do a walkthrough prior to closing, which yes, you should do. And that's great. But you do a walkthrough prior to closing. Oh, hey, don't worry about it. I'm going to get it out. Yep. The truck will be here in the morning. No problem. Right? So I don't have a simple answer for you. It's just something to think about. And you may have to end up drafting language that, that may hold the seller more accountable to getting stuff out. I probably created a big problem here just by explaining this, but these are the things I think about when I see language, and especially new language. So that's paragraph 4, you guys. Any questions, or am I out in left field or what? We don't have to answer that part. Okay, I'm not seeing any questions. Okay, paragraph 5, utilities. So of 5 utilities, to the best of seller's knowledge, seller represents that property is connected to a, but who's filling this out? The buyer's filling this out. So this is where you want to do the best you can to verify what the property has. And if things are important, make sure that this is discussed with the listing agent and listing agent seller, because this is very material. There are buyers who definitely don't want to deal with septic and things of that nature. So it's a little counterintuitive, because it's the buyer saying, okay, here's our understanding of what the property has. but it's the seller that's representing what that property has. So that might be a point you need to pause with the listing agent and make sure you're on the same page. And ultimately, whatever gets signed around, that is what the seller is representing the property has. And we just had one, I think, about within the last 90 days where it was connected to a septic tank and they thought it was a sewer. So that could be a real issue. How do you fix that, right? You don't fix that. Money usually fixes that stuff. And then paragraph 6 is with reference to new construction. But in most cases, those of you that have done new construction, you'll understand that the builder typically will have their contract that will supersede this contract. So 6 is for new construction. Now, paragraph 7, lease property review period and assumption. So this is for all that stuff like the propane tank, the security system, the stuff listed here. And how often do we actually see the paperwork and the leases on the leased property? Like people usually don't have that stuff handy, but this is one of those paragraphs I like because unless the buyer says something or throws a flag, it's going to go away. So paragraph 7, buyer acknowledges that seller leases the following, and then you check the boxes: propane tank, security system. Seller shall provide buyer a copy of the lease for the selected items within. Now, remember what I said yesterday. If you want the default, write it in. So if you want 5, write it in. Don't leave it blank, relying on the default to say 5 if not filled in. Write in 5 to help protect yourself. 5 days of mutual acceptance. If buyer, in buyer's sole discretion, does not give notice of a disapproval within 5 days of receipt of the lease, which oftentimes they're not going to get, or the date that the lease is due, which happens more often, then the lease period shall be deemed waived, satisfied. So it's gone, it goes away. And if it goes away, buyer is going to assume the lease for those items and hold the seller harmless. And that's assuming the lease can be assumed, because oftentimes those leases cannot be assumed. And like I always say, the contract that the seller has with the lessor, the provider of the item, will supersede this contract. Or the buyer can, if done timely, give a notice of disapproval. And then it says, line 47, that the agreement will terminate. And here's that language again that we've talked about. The earnest money shall be refunded to buyer. Now, remember what I said about that in past classes, that the buyer may not necessarily get the earnest money because of the process in deciding who gets the earnest money, and you need buyer and seller to sign off and come to an agreement, or the party holding the money is not going to return it or release it. So again, here's that language that I said is peppered throughout the forms that says buyer's going to get the earnest money. You got to change your language when you explain this. And as I said before, my language is the buyer would be entitled to getting the earnest money, but being entitled to it and getting it are two different things. So regardless, line 47 says that if the buyer terminates over this, then they would be entitled to the earnest money. That's 7. Okay, anything? Paragraph 8, we've had a few revisions. Homeowners Association review period. So if the property is subject to a homeowners association or other association, then seller at their expense will provide buyer a copy, and then it lists everything that seller is obligated to provide. And this also reminds me, again, to repeat what I said the other day with regards to CC&Rs, right? You're working with a buyer. Buyer wants to know if they can park their RV next to the house, build a shop, put up a basketball court, whatever. And they ask you, hey, Ken, what did the CC&R say? Can I do that? Well, remember that circle I did, and we're in the middle, and we have all these partners on the outside, and the scope of our license and what we're allowed to do, that's provide real estate services, fill in blanks on approved forms. If somebody's asking me, what do the CC&R say? Here's what I do. Here they are. Go ahead and take a look at them, buyer. Let me know what you want to do. I am not interpreting the CC&Rs. My license doesn't allow me to do that. Furthermore, who the heck wants that responsibility, right? What if you make a mistake? It's on you. So you don't want to do that. But back to 8, this is everything that the seller is being asked to provide. It rarely happens where all this stuff is provided. It's getting a little easier in the last couple of years because a lot of this information's online with these associations. But I mean, I'm in a small association where I am. We got about 19 homes. We don't have the stuff online. So the things that are listed, association rules and regs, the CC&Rs, the meeting minutes for the last 2 years, the meeting minutes from the past 6 months from the board of directors, and financial statements for the last 2 years, and the operating budget. I don't even think we have all that. I made the mistake of not showing up to an association meeting, and they made me the president. And I don't even think we have all that. Thank goodness we have a great treasurer who does everything pretty much for me. But it's rare you're going to get all this stuff, you guys, and that's okay, because this is another paragraph, like paragraph 7, that if the buyer doesn't say something, it's going away. And so I like those paragraphs. So it says on line 56 that the buyer, in the buyer's sole discretion, does not give notice within 5 days of receipt of all the docs, or, because you're probably not going to get them, the date that the above documents are due, the review period shall be deemed satisfied. So it goes away. And that's what happens most often. And then it goes on to say again in the last sentence, if buyer gives timely notice of disapproval, then the agreement shall terminate. And there it is again, earnest money shall be refunded to buyer. Right? We know about that. So buyer may be entitled to the earnest money, not buyer's going to get it. They're entitled to it. Okay, fair? That's 8. 9 is a new paragraph. 9 was born last July. And paragraph 9, homeowners association transfer fee. It says if there is a transfer fee imposed by the association or any other association, like a move-in or move-out fee, and what I say, just any cute terminology that's just designed to collect money, right? So if there's any kind of money that's owed, who's going to pay for that? And so it says the fee shall be paid by the party as provided for in the association docs. So whatever whoever is noted in the association documents, that's who pays for it. But what if the documents don't address that? Then we need the rest of the language, line 63. If the documents do not provide which party pays the fee, then it shall be paid by, and we got to check a box. And if you don't check a box, now this falls on the seller, okay? But that's a new paragraph. And when I see these new paragraphs, you know, to me, why did that paragraph, why was it created? Because there was probably some kind of fight over this in the past. And then people realized we don't have that in our forms. And so here's paragraph 9. Now on paragraph 10, excluded items, I think I talked about this day 1 on Form 21 when I put a listing in Paragon, and I'll say, well, I always use my mom's house as an example because it's safe. We bought a house years ago up here, And then around 2012, she sold it. I was the listing agent. And so with my mom, the kitchen light fixture, which we know stays with the house per the included items paragraph C in Form 21. But my mom said there's no way she's leaving that light fixture because she's had it for 35 years and et cetera, et cetera. So I put in the MLS that the light fixture, kitchen light fixture, is excluded from the sale. But that's not even close to enough, because oftentimes, well, it hasn't happened in a while. It used to happen a lot, where the broker, the buyer broker, would rely on what's in the MLS. And so in my scenario, the buyer broker would just rely on the light fixture being there because it was excluded in the MLS. And then of course the house closes and the light fixture, these days are just becoming very mixed together. The light fixture she wanted to take with her, so it would be excluded. When I got the offer, if it was not in this paragraph as excluded, then that means it would stay with the house. And so as a listing agent, when I get the offer from the person who sent it to me, I immediately looked in this paragraph, excluded items, to see if that light fixture was there, because I said, hey, expect it to be excluded in the MLS, but that has no teeth. That is an advertisement. That means nothing. It has to be in the contract. And so if it was not in the contract and we signed it around and I was rushing, then we would have had to have contractually leave the light fixture. Am I making sense? I feel like I just talked in a circle, and I hope I made sense, you guys. Maybe one cup of coffee is not enough. But I'm not seeing things light up or anything happening. So I think okay, good. Thank you, Stacy. The point is, the point I'm trying to make, all that matters is what's in the contract. Nothing else matters. It doesn't matter what's in the MLS. That is just hey, you can expect us to take the light fixture with us. But if it's not in the contract, it doesn't matter, you guys. It just doesn't matter. It has to be in the contract. And the examples that I was thinking of earlier, which I didn't articulate, would be things like, light fixture, the valances, right, on the above the windows that match the comforter on the master bed that the mother-in-law made or the mother made. They're going to take those. Well, paragraph C, that's included. That stays with the house. And if you want, seller, that to be excluded, it needs to be in the contract. And paragraph 10 in 22D is the ideal place to do that. The following items would be otherwise be included in the sale, are excluded from the sale. Seller shall repair any damage to the property caused by the removal of these excluded items. And with my mom, and I think I mentioned this earlier as well, when I'm meeting with her and she tells me, or your seller says, hey, I'm taking that light fixture with me, you know what? Perfect world, before that house goes on the market, Mom, take that light fixture down, throw something else up there. So now there's no confusion and there's no possibility of me accidentally selling it with the house. That's the perfect world, but perfect world rarely happens because in my mom's case, while I live here, I enjoy the light fixture. I'm not going to do that. So that's then, as a listing agent, I have to make darn sure when I get that offer, I have to make sure it's in paragraph 10, because I do not want to sell my mom's light fixture. And if it's not in paragraph 10, I don't then just assume that my seller, my mom, wants me to exclude it. I'm going to go to my client, explain to them, if we sign this around, this is going to stay with the house. do you still want to exclude this? It will be a counter offer. And I take direction from my seller, because a lot of times the motivation can change. Maybe my mom found a new light fixture that she likes better for the house that she's buying. Don't know, right? But we got to check in with our seller and take direction from them. Yeah, good. What about television brackets? Yeah, that comes up a lot. If sellers taking them, should they notate it here? That would be that'd be very clear. And I like that idea, because as I always say, a big part of our job is to eliminate confusion. And so that would absolutely help to eliminate confusion by everybody agreeing that those brackets that are really expensive, depending on the size, are going to go with the seller. The seller's taking them. So I love writing that stuff down. I remember one time we were out camping, and I get a text on my phone, and it's from a designated broker that I know very well. And he says, hey, what about a shed? Is that included with the house, or is that personal property? Well, how big is the shed? And so then my phone, and it's a picture. I see this kind of decorative foundation, curbing, and then decorative rocks around the curbing. And it's a cement pad in the middle. And I see these like truck marks or tractor marks down to this pad, which obviously was used to swipe the shed. And the shed was gone. What are you going to do? However, in drafting the offer, this is a business where it is okay to be redundant. In drafting the offer, write it in. We talked about it earlier. All the stuff that goes with a central vac, with a pool, a shed. If it's one of those resin sheds you get at Walmart or whatever, just write it in, because it's okay to be redundant, and that helps to eliminate confusion. So I love the idea with the brackets, writing it in there. Now, nobody is scratching their head about it. It does say, Sue, that the seller's going to fix that, right? Because some of these brackets, they can leave a hole the size of Texas. The seller's going to fix that. But that stuff comes up all the time. And remember, day one, we talked about personal property versus real property. Here was the definition I showed you guys. And this came from I know you're not reading this. I just wanted to show you how big it is. This came from the legal hotline, because this comes up all the time where people argue, well, that was real property. That should have stayed with the house because it was attached. Well, that doesn't make something real property if it's attached, because those that were on the call recall me telling you I'm from Southern California. We attach everything to the walls because of our earthquakes. So that doesn't mean our China hutch is now real property that is part of the house. That's ridiculous. When we look at real versus personal, it gets into how big it is, what it takes to remove it, what damage is done in removing it, what's the relationship between that property and the house itself. And as this says here from the legal hotline, I have it highlighted. There's no clear-cut answer. So it's completely subjective. And that's why, to avoid all that stuff, write it in the contract. And now we're not having to deal with the subjectivity around the definition of real versus personal. Does that help? How are we doing? 10:34. But just don't rely on what's listed in the MLS, because that doesn't matter. It has to be in the contract. And then paragraph 11 on home warranty. Buyer and seller acknowledge that home warranty plans are available, which may provide additional protection and benefits to buyer and seller. And that last sentence there is what people end up in the weeds over. It says buyer shall order a 1-year home warranty as follows. A lot of times we're relying on the seller, the listing agent, we don't think about it. It never gets ordered, never gets paid for. When the contract, the intent was for the seller to provide a home warranty, nobody orders it because everybody thought the other person was going to order it. And buyer broker is going to, in most cases, probably end up buying a one-year home warranty for the buyer when the seller should have done that. And line 71 clearly says, buyer shall order a one-year home warranty. So just on your checklist, make sure that doesn't get skipped. And then make sure that ends up on the closing document so buyer gets their warranty. I have a note here on possible E&O requirements, and this is around if you, as a licensee, are selling your own house, check with your broker. There may be some requirements in order to have E&O coverage, and you want E&O coverage when you are selling your own house because you are a bigger target. And some of the requirements are things like a buyer must do I'm looking to see who's not muted. A buyer must do a home inspection. Must have a home inspection done by a home inspector, a licensed home inspector. So hang on, I think that's not. Whoop, there we go. Some of the E&O requirements are things like there must be a home inspection done by a licensed home inspector on the property. Now, seller doesn't have to pay for it. In most cases, right? Buyer does a home inspection. But as we'll learn with Form 35, a buyer is able to do a home inspection, but not in this case. It has to be done by a licensed home inspector. So that's a possible requirement to have E&O coverage when you are acting as your own listing agent on a home you own. The other requirement is that buyers will receive a one-year home warranty. Again, it doesn't matter who pays for it, but buyers to get a one-year home warranty. So those are the biggest requirements around errors and omissions. To have errors and omissions coverage. So check with your broker if you're going to sell your own house because you want coverage, and those may be requirements in order to get coverage. Let's see, Stacy, how can I get my hands on a copy? That is on the hotline. I have plenty of copies as well, so you can get it from me. You can type in probably real property versus personal property in the hotline, and that'll pop up. I may have it on my desktop, which I can send to you. And let's see, in the unlikely event the buyer decides not to order a home warranty, should you still check the box to acknowledge the home warranty is available? Oh, thank you. Should you still check the box to acknowledge the home warranty is available? If so, should we add none under warranty and 0 under seller shall pay? Okay, thank you, Adrianne. So I went to the state forms committee maybe about 3 months ago because what I was hearing from the home warranty folks, now they're home warranty folks, right, who want to sell home warranties. But what I was hearing was that there's more and more litigation around home warranties and buyers claiming they didn't know they could get a home warranty, right? Claiming they didn't know they could get a home warranty. They buy the house, appliances fail. They're having now to spend money and somehow like, oh, they found out had I had a home warranty, I wouldn't have to spend this money. And remember, it's your fault. It just is. So I went to the state forms committee and said, because this is happening more and more, what about having, you know, like when you rent a car, you got to sign off that you decline. What about having something like that on the home warranty paragraph where buyer says, I don't want a home warranty. Okay, initial there. So I don't get thrown under the bus 7 months later when your dishwasher, refrigerator, and garbage disposal fail and you have to buy all that new stuff. And they came back. Because if we do that, there's all these other places in the contract then that we would have to do similar things. And I've heard that before from lawyers. So I'm used to that answer. So now what I tell people, and what I'll do is with a buyer, if you don't want the home warranty, I will write declined and a line and have the buyer sign. I'll do it myself. So I am absolutely okay with that happening. Absolutely. So hopefully that answers that question. Sue, I've just seen that Freedom Home Warranty has closed their doors. I just wrote in a PSA that seller would pay for a Freedom Home Warranty. Well, I need to do a counter to arrange it with a different, oh boy. Close their doors. So Sue, what I would do is if you have a local rep, boy. Well, I guess it would be, So I don't know if there's anybody you can still talk to at Freedom. Maybe not because they closed their doors. I'm also thinking about what about the warranties in place? What happens to those? Those are questions I would ask. And devastating news of closing our doors. We made every effort to salvage the oh, good golly. Okay, so if there's nobody to talk to with Freedom, I would, and I don't know where you are in Washington, Sue, I would, and if you say you're in Spokane with Keller Williams, I'm going to be embarrassed. But Richland, okay. Call, you know what I would do? Because I know Kelly Quinn services the Richland area. Call her and see if she has any insight, because I'm wondering what happens to the existing warranties in place. Sometimes other companies absorb those, but start with Kelly Quinn, and if you don't have her info, throw me an email and I'll give it to you. See if she has any insight on that. But for your existing contract, yeah, I would absolutely do an addendum with another home warranty company. I would absolutely do that. And that also reminds me, and I haven't talked about this yet, I see it. Like, let's take this, for example, this scenario. We have a signed around contract and we have to make a change. What I see brokers doing, and you don't do this, it's a signed around contract. They'll go and strike and write in, something else, and then have people acknowledge that. But this contract's already mutually accepted and signed around. You can't do that to a contract. Instead, you would do an addendum and you would reference this paragraph. And I mean, you could, on this contract, you could do a line and say, see Form 34 or something, but you don't want to make the change on a contract that's already been accepted. So do like a 34 in reference to line 11, Form 22D optional clauses, seller to receive. Okay, thanks, Russ. There's Kelly Quinn's number, Sue. Seller to receive a home warranty, and just change the name of the home warranty company. But that would be a very appropriate change to make. And I assume you guys, okay, you can see everybody's, okay, gosh, you guys are great. So, and you can see the text, it looks like, because Sue said thank you, so you can see it. Okay, good. So that's the home warranty. Anything before I keep going? So paragraph 12, you guys, is like a little Form 34. It's just a little blank area, just like a little 34. So something that if I'll write in paragraph 12, if I'm a buyer broker, well, let me ask you. We talked about CO detectors, right? And we know they're not CO2 detectors, they're CO detectors. So if the appraiser goes out and the CO detectors are not there, and the appraiser says, hey, Ken, $100 for me to come back and re-inspect, let me know when they're here. Who pays that $100 or $150? Now, usually in class, you guys, you're split like 50-50. Buyer, seller, because the seller is supposed to provide them but it's because the buyer's getting a loan that's triggering this. And the point I make when y'all are like, you know, less filling tastes great, less filling tastes great, is that it's not clear. Clearly, it's not clear. So as a buyer broker, something I will write in paragraph 12 would be, seller will install CO detectors per state statute prior to appraisal. I can never say that word. If seller fails to do so, seller will pay for any reinspection fees charged by the appraiser to confirm this has been done. Who's paying for it? That's pretty clear, isn't it? I'll read it again. As a buyer broker, now as a listing agent, that's not something I would necessarily write there, but as a buyer broker, seller will install CO detectors per state statute prior to appraisal. If seller fails to do so, seller will pay for any reinspection fees charged by the appraiser to confirm this has been done. I am eliminating confusion. So that is something I would write in paragraph 12. Other things you could write there. Remember, you have to disclose if you're a principal in the transaction. So if I'm buying a piece of property, I would write buyer is a licensed real estate broker in the state of Washington. That could be there. Just again, think of it as a little 34. That is optional clauses, you guys. And we have about 12 minutes. Is there any questions? My plan today is to run to the office and get a whiteboard because a couple things are going on. The next form I would get into is Form 3535R, the inspection response, and I got to do a whiteboard. So my goal is to get a whiteboard and have it behind me. And my other goal today is the DOL has given me instructions on what I need to do to get my entire statewide forms class approved for clock hours to deliver via Zoom, as well as a class that I got clock houred about 2 months ago, biggest bloopers and blunders we are making on the statewide forms. That's a 3.5 clock hour class. My forms class is 7.5. So it's the thought of teaching an all-day class at my kitchen table is a little different for me. But my goal is today to get that stuff into the DOL, and then my classes will be approved for clock hours via Zoom. And so maybe next week, I'll pick a day and a time, maybe not do the statewide forms class, the all day one. Maybe I'll start with the 3.5 hour class, the bloopers and blunders, and pick a day next week where it'll be 3.5 clock hours. And I'm not charging for any of this stuff. There's just no way I can with what's going on. But you will get 3.5 clock hours. Now, since I got a bunch of you here, here are the requirements the DOL has put on me and you to do this. And it would be, I got to see you. So just like I can see Amy there, I got to be able to see you because obviously you got to be here. And I have to explain the format, which you already know what the format is. We'll still have our breaks. And while I'm teaching, you can't disappear. They said I have to be able to see you. I got to write down your names. So I got to take roll. But hey, that's not too bad, right? I mean, you got to do that anyways. So I'm going to anticipate teaching my bloopers and blunders next week for 3.5 clock hours. But like I said, those are the requirements the DOL has put on us. I got to see you. You can't disappear on me. We'll still have our break, and I'll take roll. Yeah, that's pretty straightforward. Good. Anything else, you guys? Let's see, 10:49. I can end with this. So like I said, the next form I'll get into is Form 3535R. And I always start by talking about Douglas versus Visser. Is anyone familiar with Douglas versus Visser? Yeah. So that was a lawsuit in 2010 that completely kind of changed the way we look at home inspections and buyers' obligation to do a home inspection. So I won't bore you now. It's 10:50. It's okay. We're getting out early. There's no clock hours for this. But if you get bored today, look up Douglas versus Visser. It's a fascinating case. I'll touch on it when we do our 3535R class. And like I said, my intent is to do it tomorrow, but that's dependent on me getting to my office. For those that are not in Spokane, it's snowing and it snowed last night. Getting to my office, and I got to get in the storeroom, which my master key doesn't work on, but somebody told me a way to break in. So if I can break in successfully and get my whiteboard and have it behind me, I'll do that. So that's my intent for tomorrow. I will update you via my Facebook page. You can email me if you want, ken@kensachs.net. I'll type it so you know how to get a hold of me, ken@kensachs.net. And for those with KW, you'll see it in all our internal stuff. So that's my plan, you guys. Anything at all? Anything real estate, contract, broker stuff? Anything you want to throw at me? All right, let people know what we're doing here, because classes are shut down, obviously, all over. I was supposed to be in Walla Walla teaching, so this is just my way of trying to do what I can to keep us going. We still need to get educated. If you got new agents in your office, bring them in. I don't care who's in here. I want as many people as possible in here because, like I said, we're all in it together, really.
Thank you, Ken.
Yeah, you betcha. All right, you guys. Stay positive. Amen, Amy.
Thank you.
All right. Bye, guys.
Bye, everyone.